Everybody ready?
Yeah, put us live so we get everybody on there.
Yeah. Hey, can I handle the description of what an initiative is?
Okay.
Because I think we start there. Otherwise,
Yeah, no, absolutely. That's part of the process, you know.
Okay.
And
let me handle that because I just authored an article on it, so I'm up to speed.
No, this is great. Destiny, are you getting us live?
I'm about to go.
Ooh, that was echoey.
Everybody ready?
Ready.
Yeah, live. Put us live.
Yes, those are fluffy clouds in my background.
I always play our theme music now for Mita behind the scenes. So just chill out for a second. Everybody, you know, say hi to the person next to you. You know, this is like, Robert, you got to play along here.
Well, what am I supposed to do?
You gotta wave at the window next to you.
Oh,
The whole Brady Bunch thing.
and I go one of these.
You just gotta say hi to everybody.
Love it.
You gotta have some fun with it. Let it
It's not a
populate for a
diverse
second.
panel. Dimitri, it's not a diverse panel.
We're gonna have this rewritten for the Mita Bunch.
And then meet him.
By the way, kudos to Robert for wearing a coat indoors in Arizona. In
Do you have a
August.
dress code at my law firm?
All right. Enough of that, right? So, folks out there in Zoom land, welcome to the 7th or 8th Mita Town Hall event. Today, we're focusing on Smart and Safe, the initiative, and the recent legal challenge to it, what it means, if it means everything, anything at all. And that's why we have some of the best on here to talk about it. We are looking for ideas. We have a number of town hall concepts coming up. You can look online on Mita for what those town hall concepts are. But we're going to be doing one a week, and we're looking for panelists. We're looking for sponsors. We're trying to showcase Arizona's best to Arizona, to the nation, create a historical record, which is available on www.mita-az.org. We're also live on Facebook. I've been finding that crazy things happen for people. They've come back to me and said they've got crazy leads and consulting gigs, and it's fantastic what we're doing is showcasing Arizona's best. And to the world, you know, LinkedIn, we're doing promotion everywhere. So you guys, again, thank you for joining us. And today it's all about smart and safe adult use legalization. So let's get right to it and focus on that. As we know, we're all locked in. And one of the greatest things about these Zoom meetings is we're getting to do a little bit of like networking with some of the experts in the Arizona world. So let me start by allowing the panel to self-introduce. Let's start with he who is best at introducing himself, and that would be Tom Dean.
I
Dean,
see.
That's
a new title I haven't had before. All right.
So watch us as we all raise our hand. It's time to slow down.
Okay. Yeah. So, hey, good to be here, everybody. I know that a lot of you probably know me. My name's Tom Dean. I've been a marijuana lawyer now for decades. I got my start kind of doing marijuana when I was litigation director back in the late 90s at Normal, their headquarters in Washington, D.C., National Organization for the Reform of Marijuana Laws. Did a lot of cases on a national level back then. Have been here now in Phoenix specifically for about 10 years. Came back about the time that the Medical Marijuana Act passed. I'd previously practiced here up in Flagstaff for many years, for several years. And so at this point now, I do only marijuana related cases. My website, attorneyforcannabis.com, sums it all up. That's what I do. And I've been involved in most every of the key cases here since the Medical Marijuana Act has passed, and look forward to continuing to do that to uphold the rights of patients and to expand the rights of both patients, providers, and hopefully coming soon, adults under the Smart and Safe Act.
Yeah, and Tom, if I may give you a compliment publicly in front of a lot of people, you really helped out a friend of mine who was in need. You charged her an unbelievably low rate, and you got that DUI pled down to a reckless. And you know, you are Sonia's fantastic. I love her too, but you are my #1 criminal marijuana related reference right now. So thank you for helping.
All right, that means a lot. Thank you, Dimitri.
Yeah, well, let's move on to Robert Mandel, famous for the Jones case. You can talk a little bit about that and who you are and your relation to the industry.
Well, thank you, Dimitri. It's great to be with everyone. I'm a partner with the law firm of Zuber, Lawler, and Del Duca. We have a national footprint in the cannabis space. We provide legal services ranging from litigation to mergers and acquisitions to patents and all sorts of other intellectual property work in the cannabis space, but also in other interesting spaces like blockchain and esports. And we also have, a full service. We offer full service to any industry. Yes. So my history with cannabis cases goes back a few years to the Rodney Jones case, where the AMA was in serious jeopardy. The Arizona Medical Marijuana Act, its future in the state, was in jeopardy. And with a great team that included a lot of people who are actually panelists here, we were able to fight back the forces of evil and make sure that both the industry would survive and that the patients would be able to continue to avail themselves of these medicines. And I was grateful for that opportunity. I'm delighted to be here. And that's really about it.
Well, Robert, the industry owes you a thank you. And, you really did a great job on the Jones case. And well, he owes you. I mean, that poor guy. But one of the best things about Smart and Safe is there won't be that circumstance again.
Yes.
That's a great thing.
So right.
Let's move on to the man who's in my center square. This could be a tic-tac-toe game as well. You would be the X or the O. That would I put first right now, Ryan, and my thing, because you're in the center. Sorry. Tangent. Ryan Hurley.
Yeah, my center, as always, is Tom Dean. So
Yeah.
My name is Ryan Hurley. I am a cannabis attorney here in Arizona for the better part of the last decade. I've been focused exclusively in the cannabis industry. I currently am general counsel at Copper State Farms, which also includes our dispensary brand, Soulflower. Dimitri, nice T-shirt on your smiley face guy there. I like that. Before that, I was chair of the cannabis practice group at Rose Law Group, and have been involved in all aspects of Arizona's medical marijuana law, and of course the various efforts to try to legalize adult use cannabis here in Arizona. Happy to be here. Honored to be on here with all these distinguished panelists.
Yeah, thank you, Ryan. And Ryan, you're a legend. You're highly credible. You have Mike Fleischman's recommendation, which is the first thing I ever learned about you. And Mike Fleischman, of course, is a great hero of mine, attorney down in Tucson, a really good man. So thank you for joining us, Ryan. And yeah, that's Soulflower. This is Danielle today. She's happy. She's here. She's chilling. She's actually out of town, so I had to represent her. If you guys, know me, I'm frank, I'm honest, and transparent. So, I just lay things out there. I might secretly disclose the meaning of life during this hour-and-a-half long conversation. So stay tuned, folks. You're going to get nothing but truth and honesty. And we are surrounded here by guys that believe in the same thing. So thank you guys again for participating. On to the next gentleman, Gary Smith. Oh, your audio, you're on mute, Gary. With all that fancy equipment, you're still on mute.
Well, I'm using my computer. And I was going to say, I'm noticing, seeing myself on video, I am overdue for a tan. Oh my God. So sorry, everybody, if the glare is wiping out your screen. Anyway, hi there. I'm Gary Smith. I am a 30-year experienced litigation attorney. The last 10 of those years has been spent doing a deep dive on cannabis. Back when AMA got started and Ryan was running around helping to set up all the dispensaries, I was trailing behind him waiting for the litigation to start, and thank God it did, because that's filled my plate for the last decade and probably will continue to do so, which of course leads me to have opportunities like this to talk to you all today. In addition to my 30-year practice and my 10 years of cannabis work, I'm a founding partner at Guidant Law Firm. I am also one of the founding directors and current president of the Arizona Cannabis Bar Association. I'm also a board member of the Arizona Cannabis Chamber of Commerce. And since this is opportunity for shameless plug, if you look above me, as of Saturday, August 1, I am now also a published author of world's first book on psychedelics and plant medicines, including cannabis, which is available for sale now on Amazon. Sorry, I had to plug it.
No, it's okay.
I'm thrilled to be here, and I really appreciate having a chance to talk with everybody today about the initiative. So, Dimitri, if you want to pass the mic and finish introductions, I'd love to dive into the topic.
Yeah, well, one last thing. You may want to speak up, Gary. I think your audio is a little low.
Oh, okay.
Sam, you're up. I like the hat today. Very nice.
I wore it just for you.
I appreciate that.
Great to be here, everybody. Sam Richard, qualified patient, and lucky to be the executive director of the Arizona Dispensaries Association, and grateful for the conversation. I'm not a lawyer, as my T-shirt amongst all of you with your blazers and ties and collared shirts might indicate, but definitely following these conversations very closely, and happy to be a part of the conversation this afternoon.
Okay, let's jump into it. Yeah, thanks guys for all the introductions. Ladies and gentlemen out there watching this, these are some of the smartest men in Arizona cannabis. So stay tuned. You're going to learn a lot here about our industry, about the laws, about the regulations. And let's start out with a little bit about where we're at. Why did we have to go through the initiative process, where we're at, and then we'll get into what's happening with the court. Do you want to start with that, Gary, or?
Yeah, absolutely. I'm happy to. By the way, you said the audio is low. Is this any better now?
That's better. You're good.
Okay, I raised my volume as well. I didn't touch
Excellent.
it. Okay, so what brings us here today is to talk about a lawsuit that just got filed a few weeks ago, trying to keep the Smart and Safe Recreational Initiative off the Arizona ballot for November. The attack is strictly and exclusively to prevent it from being on the ballot, so that the public doesn't even have the opportunity to vote on it. So that being said, let me pause and explain what an initiative is, because without that, the rest of this conversation is going to be a little meaningless to some people. So start with the premise that if you ever watched Schoolhouse Rock as a kid, or even as an adult, you shouldn't rule it out, you may remember the episode about I'm Just a Bill. And that episode talks about how laws get made in this country. And they get made principally at a legislature who will have committees and different drafts and legislative council, and they'll vote on it. And it passes through that pathway to become a law. And if the legislature votes on it, it lands on the governor's desk and either signs it or vetoes it. But there is a second side door avenue by which laws can be made, and that's called a public initiative. And out of all the states in the nation, there are only 24 states total that permit public initiatives. And Arizona is one of those states. And the right of initiative is baked right into our state constitution. And it provides that the public can, without the legislature's involvement, craft a law, get it onto a ballot to be voted on, and if it's appropriately voted on, it becomes state law, same as if it had originated inside the legislature. So that's what's going on here right now, is that just like AMA 10 years, really almost 11 years ago now, for being accurate, that's how AMA got passed. Because as we all know, we have a state legislature that's kind of hostile to cannabis, and they're never going to take it up, they're never going to embrace it, and they're never going to pass a law on it. So the public got together and created AMA. And here we are a decade later, the public is ready for recreational and the legislature still is not.
So Smart and Safe filed their initiative. When did they file the initiative? Was it July 1st?
I couldn't tell you the precise date from memory. Yeah, if any of the other panelists knows.
It would be September 26th of 19.
No, that was the original filing. Yeah.
July 2nd.
July. Yeah. With how many signatures about, Sam?
We filed 420,000 signatures just a couple of weeks ago.
Excellent. And so now we're under a legal challenge. The petitioners in this case, and we'll get into who they are in a second. There's a legal challenge against it, which is the right of any citizen. Is that correct? Anyone?
Yeah. And anybody who's a citizen of the state has the right to attack or to challenge an initiative. And that's exactly what's happened here.
Okay, so so the petitioners are, Ryan, I think you probably know better than anyone. Who are the petitioners in this case, and why have they challenged Smart and Safe in the courts?
So it's a cast of recognizable characters, the same folks that have opposed any sort of cannabis progress here in Arizona from the get-go, spearheaded by Kathy Herod at I can't remember the name of her organization right now, but she's the family values person.
Center for Arizona Policy.
There you go, Center for Arizona Policy. And, you know, she's kind of a fringe lunatic of the far right. And she has buddied up with Sheila Polk and her likes, the folks from MAP Force that we're all familiar with that have opposed medical marijuana at every single turn, that have tried to take medicine out of people's hands, that have tried to arrest people for, and successfully have arrested people for using medical cannabis concentrates. So it's the same cast of characters. And I find it notable that they hired a very expensive law firm, and they clearly put a lot of effort behind this because this is pretty much their only shot at stopping us, and they know it. So they have taken all their budget and thrown it at this effort.
Yeah, I think you're right. And Tom, why do you think that they chose the court route rather than to spend a couple $100,000 on the Vote No campaign?
Well, I think that it's because they didn't have any money. Unlike in 2016, when the opposition was very well funded, this time around there really isn't that much money. And so while they may have spent a good deal on a law firm here to file this, it's a heck of a lot less than what they spent last year to put billboards all over town and that sort of thing. So with their limited budget, I think they looked at this as really the only chance they had to do two things. One, maybe, try to challenge it and who knows, maybe be able to prevail in a court of law. But also I think as importantly, they were able to get a lot of attention in the media without spending much money. So, headlines across Arizona on this. And as this plays out, they're continuing to get attention. And I think that's really more what they're using this for this lawsuit. It's hard for me to believe that they really think that they have a good chance of winning this. I'll see what my fellow panelists say, because in my view, looking at their arguments and then looking at the arguments made on behalf of the initiative, Smart and Safe initiative, I think it's pretty clear to me that I don't think that they're going to prevail.
And we'll get into the arguments in 1 second. Let's get to Robert up here. So there was this oral arguments for today. Let's go through the process of what happens next, timeline wise.
Sure.
And regarding what people should expect out there.
Well, they have to move very quickly. We're expecting a decision from Judge Smith in relatively short order. And you can expect that almost instantly. After that decision comes down, there'll be a special action petition filed with the Arizona Supreme Court, and that the parties will be asked to argue very, very quickly. And they have to move very quickly because I believe they're about to print these. We're up against a ballot printing deadline, so they have to
August
move.
21st.
You're right, and that's not a whole lot of time. And the Supreme Court has, what I've seen most recently is they will make the decision and then they'll explain the decision later. So we may not know all of the reasons for the court's decision before before August, whatever that date was that you mentioned. We'll know their decision, but we may not know the reasoning behind it. That decision will be most likely, if they follow the same practice, will come out later.
Is it possible that this thing could still be going through litigation while it's on the ballot?
I don't think so. I think that it has to be decided before then. But as I was saying, what the basis of the decision will be may be a mystery to us until afterward.
Right. So either we're going to have a big Zoom call discussing a negative decision, right, or just a nothing burger.
Right, exactly. But we don't say that. It's going to be a great decision, and it's going to work out.
Excellent. Before we move on, I want to talk to just real quickly, Sam, about any political aspects or media aspects that we've left out before we get into the meat of the matter. But does anyone know if Judge Smith smoked pot in law school?
I actually looked up his judicial biography because I had asking that somebody would ask a question like that. He looks like he's got a really conservative background, and listening to arguments earlier, I was shocked. He seemed quite the opposite of how he looks on paper.
Yeah. Well, you know, I heard that Sheila Polk might have partake. That's what I heard in passing from one of her fellow classmates in law school. That's why I asked the question, because I think it, you know, it's interesting. Maybe it's not relevant, but it sure is interesting. Sorry.
I think he's got a very good reputation, and I think he calls them like he sees them.
Yeah, he really seemed to understand the issues as I was listening to the argument. So
he asked better questions than I think I could have formulated. He really asked some great questions today, right off the bat.
Oh yeah.
Yeah.
Questions that weren't even briefed, you know.
Sam, anything else about the politics or the time frame here before we get into the subject matter, the merit of the lawsuit?
Yeah, not really. These gentlemen did a great job setting the stage. One thing I would add, as far as the reason why, or the kind of impetus behind the challenge, in addition to some of the ideas offered here, it's a great vehicle for folks to fundraise, right? I think because of the coronavirus effects across the country, we are one of the very few legalization efforts happening across the country. So a lot of the national prohibitionists and antis are really looking at Arizona. So there's a huge opportunity to fundraise for groups like, No Connection, No Relation, but the group called SAM, right? Smart Approaches to Marijuana, which I'm sure many of you are familiar with. They've been fundraising off of this quite a bit, as are others. So that would be the only other thing that I would add as far as a reason why this challenge was brought.
Excellent. Thank you, Sam. Okay, so getting into the legal aspect of it, it seems to be that, and you guys can expand on this, that they're not challenging the constitutionality of it or the merit of it, but the summary of what's in the 10,000 word document, as the lawyer refers to it as, the 100-word summary. And we can get into the provisions. How does that work with the 100-word summary? What is the duty of the gatherers? Why is that so important? Anybody want to start on that, Ryan or Robert?
Yeah, it looks like Gary's got the specifics there, but essentially, you can't give the whole. Well, most voters won't read the whole 17 or 27 page initiative or whatever it is, and so the procedure is you have to give them a 100-word summary for them to review, so they can determine whether to sign the initiative and place it on the ballot in the first place. And the basic requirement is that you have to summarize the principal provisions of the initiative. You obviously can't put everything in there, and the court has acknowledged that, but you have to summarize the principal provisions, and it cannot be misleading, is the standard.
So this judge is looking at this 100-word summary, and he has to decide whether that summarizes the 10,000 word document.
Well,
Robert?
it's a matter of whether it summarizes the principal provisions. And of course, using that language is a recipe for disaster, because if you put any two lawyers in a room with the 17-page single-spaced initiative and ask them which of these provisions are the principal provisions, you'll get 12 opinions. And a lot of those opinions are, a result of what that particular lawyer's, specific focus is. So some of the provisions from the perspective of the industry are going to be, the industry is going to look at certain provisions as the principal provisions, but, average Joe on the street may look at other provisions as the principal provisions. So it's a little bit tricky for sure, but looking at those 100 words that Gary was just showing us on the screen, I think that somebody spent a really long time making sure that this captured the key provisions. And I think that fact is reflected in the frivolity of the arguments that have been raised in the injunction petition and in court today.
And I think, Dimitri, too, that the summary is supposed to summarize without being fraudulent or confusing. And those are the two touchstones. Does it have anything that's incorrect in it? Does it say something that's not true? And then does it say something in a way that's, patently confusing that would be confusing to the voters. And that's the approach that the lawsuit took, the complaint in this case, and listed a number of different things. Like, for example, the 16% excise tax, the provisions relating to DUI, the definition of marijuana, and a couple other things that they really directly attacked and trying to argue that somehow it was confusing or somehow not true.
And Tom, and we'll get into those provisions here next. Just real quickly, Gary, the judge kept talking about the reasonable person. Who decides what a reasonable person is?
Well,
what does that mean?
Judge. Yeah, it's going to be the judge, and a lot of that came up too. I'm glad you brought that up, Dimitri, because when I was listening to the oral argument, it was pointed out that the plaintiffs here don't have any evidence. They have presented no evidence. And even the judge, I think it was the judge who commented that isn't this really just the subjective personal opinion of the plaintiffs? And of course, I think Rupali during her part of the argument pointed out that it would be naturally self-serving of these individuals who are anti-cannabis to say anti-cannabis things about the initiative. So there's no evidence on this record. So ultimately, if the judge decides that it can still move forward even in the absence of evidence, it's going to be the judge's personal subjective opinion about what a reasonable human being would find when reading a 100-word summary of a 17-page initiative. Or to put a fine point on it, it took a 17-page complaint to gripe about a 100-word summary about a 17-page initiative.
That's kind of funny.
For you right there, nothing will.
And Robert or Ryan, any of you guys can explain why do we have a 10,000 word document, and that's actually probably inadequate to change the marijuana laws? Why is it so complicated? Maybe you can elaborate on that. Why it needs to be that way?
Well, you're not really changing the marijuana laws per se. What you're doing is you're creating an immunity to criminal statutes in Arizona that, and this will probably bring back memories of the Rodney Jones case. We have a peculiar statutory regime in Arizona that distinguishes in the criminal law between the flower of the cannabis plant and essentially everything else. And it's a false distinction, but it nonetheless exists. Why is it a false distinction? Well, because what the criminal code defines as cannabis, which is essentially the resin of the plant, as opposed to the flower, is meaningless because the flower has the resin in it. And so, but nonetheless, the criminal statute makes that distinction in it, and it considers cannabis it treats the use and possession of it much more harshly than it does the flower. So this, as I said, this was, prominent issue in the Rodney Jones case with regard to the Arizona Medical Marijuana Act. Now, what the drafters of this initiative have done is they have essentially cured some of the issues with the definition in the Arizona Medical Marijuana Act by making that definition explicit in this particular initiative, and I think that's really probably the crux of the dispute that we're looking at. The opponents of this petition are adamantly opposed to any definition of marijuana that embraces anything other than the flower. They don't love the flower, but anything that's made with the resin, they're adamantly opposed to. And so that's probably their first argument and the one they're leading with. And it really doesn't have a lot of it doesn't have a lot of oomph behind it, because the reality is that as I read this 100-word statement, from my subjective perspective, I don't see how a reasonable person would look at the language as it's written and say, oh, that term marijuana must mean what the criminal statute says, as opposed to saying to themselves, because it says in parens after it as defined, I think the average person would say as defined means in this big document you've just handed me to look at, which is the initiative itself.
And that was going to be my next question. You
Yeah.
know, it seems like they're concerned about the material alteration of the definition of marijuana, but you can't put an entire material alteration of the definition of marijuana into a 100-word summary.
No, if you've looked at the definition, it may approach 100 words. It's very long, and it
Just
needs
the
to be.
definition of some-
Yeah.
Just, Ryan, did you want to comment on that? Let's talk about the material alteration of the definition of marijuana and how they're complaining that it's not in the actual 100-word summary. You know, it just doesn't make sense that.
Yeah, and it wasn't even that. I mean, it's in there, right? It says as defined.
Right.
What they were arguing is that, you know, the average voter wouldn't know which definition they were referring to. And, you know, I mean, the average voter wouldn't even understand that there is a definition of marijuana in two different places that might mean two different things, but that the Supreme Court has actually decided mean the same thing, right? So their argument on that one was pretty weak, and frankly, you know, based on what I heard during the hearing, the judge didn't seem to buy it much. You know, it's almost as though they wanted to relitigate the Jones case that they lost
Right.
so badly. They just couldn't understand how they lost that, and so they just wanted to jab it one more time, and I just don't think it's going to be successful for them.
So let's assume that left uppercut is not going to be successful. Let's move on to number 2, the tax issue. The judge, they kept talking about how the tax issue should have been included in the 100-word summary. Can any of you guys elaborate on that, the merit of that, and what they're trying to say? And I apologize because I'm not an expert in this field. I'm trying to keep up here. Gary?
Yeah, where that comes from, and the reason they were hammering on the tax issue is that Arizona, until I think last Friday, had literally only one case that's ever decided this initiative question. Now we have 2, because the Red with Ed or Red for Ed thing got nixed by the Supreme Court. So the prior case is the Malera case that talks about a change in tax. And then of course we had Red for Ed. I keep butchering that. I'm so sorry. Red for Ed also got nixed because of what they consider to be a misdescription of the impact on taxes. Because what I think the campaign was going to do was modify tax brackets and tax rates. So here, what the plaintiffs have latched onto, which I don't think is a very strong argument, but I understand why they did it, was to pick on the tax structure that's going to be imposed on cannabis and say, see, it's the same thing. But it's not at all, because it's a sales tax versus an income tax. And the only precedent we had is an income tax argument. And again, that's why they latched on to tax. But it's not even remotely the same thing. The only 2 things in common between the earlier Malera case and the Red for Ed case versus this case is the word tax. That's it. The tax structures are not the same, the tax arguments are not the same, and the impact on the public is not the same, because I think every single person who would vote for the initiative, the Smart and Safe initiative that is, understands that when they go and make a purchase, they're probably going to pay some sales tax. I don't think anybody is walking around with a misunderstanding about that reality.
Ryan, you want to go into, because I was still a little confused. I'm sorry, I'm a little bit of a layman here. Actually, I'm a lot of layman compared to you guys. You know, it seemed like the petitioner, Shedegg, kept going back and forth between, you know, they can't do this, but even if they think they can do this, they should have included in the summary because it's a big deal. Is that kind of what they were saying?
You know, it's interesting. The tax provision was not one that the plaintiffs focused on in their oral arguments. I think they even thought that was a weak argument. It was the one area of inquiry that the judge seemed to focus on when he talked to Rupali, the Safe and Smart attorney, Smart and Safe attorney. And you know, his question basically was trying to hone in on the fact that the initiative says that you know, beyond the 16% tax, no additional fee or surcharge or tax can be added beyond what the initiative says. And the judge seemed to wanted to know whether that was an additional prohibition beyond the existing Voter Protection Act that prohibits the legislature from monkeying around with initiatives after they're passed. And whether, if that was the case, whether it had to be disclosed in the 100-word summary. I frankly was having a bit of a hard time following his logic as well, as to why that could have been included. I mean, essentially, if you follow that line of reasoning, then the 100-word summary would have to state every single thing that the legislature was prescribed from doing, to change the initiative. So I think maybe he was trying to give the plaintiffs a bone there, and trying to get to something, but at the end of the day, I don't think there's anything there either.
Robert, did you want to comment on this?
I echo what Ryan said and Gary on that. So no, not too much to offer there.
Tom, I feel like I'm leaving you out here.
Yeah, the only thing I would add is that I think that the Smart and Safe made an argument in their briefs too, that because the complaint was that they didn't explain in the summary that the 16% excise tax couldn't be increased. That was the complaint, but that's not necessarily true. There is a process by which the legislature can modify an initiative. It just has to be done in conformance with the Voter Protection Act. So it's speculating to say that it can't be increased, really. And certainly it could be increased in a future initiative. So to say that it's impossible to be increased would not be accurate.
So right now, as it stands, if this initiative passes, which we all hope it passes, does the legislature have the power to increase the tax? Will the legislature have the power to, and this is kind of off the point, will they have the power to increase the tax beyond?
They're not
16%?
Dimitri, they're not, the initiative seeks to prevent them from doing that, but whether or not they are able to, if they try in the future, would be subject to, that would be something that could be debated. They'd have to do so in compliance with the Voter Protection Act.
They also theoretically could do it by raising the general applicable sales tax, right? And that was the other thing that Rupali focused on is, look, if they want to raise the taxes on this, then they can raise the sales tax in general, and that would raise taxes on cannabis.
Yeah, we need to be careful about that as an industry and make sure that we fight that aggressively in a united front, because any increase in taxes goes right on to the patients, the consumers, and just enables a black market. So
well, and the good thing about that is every other retailer in the state, regardless of what they sold, would join us, right? They would have to fight that as well.
Oh, as a whole crew. Well, that's well thought out.
Yeah, and don't forget also, you've got two arguments there against any sort of like outrageous tax increase. You've of course got the Voter Protection Act, which will protect AMA and then ultimately Smart and Safe if it passes. But then also there's a 200-year-old precedent from the Supreme Court, McCulloch versus Maryland, which stands for the proposition that the power to tax is the power to destroy. That is the literal holding of that case. So there are constitutional concerns that if you put a tax so offensively high as to impair this industry or kill it, that tax would not stand up to scrutiny in a court.
Okay, and you feel free just to chime in. Don't, I'm not, don't, you have to raise your hand or anything. Just jump in anytime.
We're afraid of you, Dimitri.
No, I know a little bit. I know enough. So.
My favorite argument of the plaintiffs was that the initiative doesn't tax home grow.
Oh, that's right.
I thought was ridiculous because you're not selling your home grow, right? Your home grow is for you. So why on earth would we tax it? That was just a ridiculous argument that I can't even believe they put pen to paper on that one.
So they're more concerned about it not being in the summary than the actual tax in the end. That was their main point. Is that correct?
They're
okay.
Concerned, if anything, they think they can throw at the wall that might stick to get us off the ballot. That's all it is.
Yeah. The more I break it down, the more it's just ridiculous. The third material thing that they kept bringing up was the changes in the burden of the DUI proof. Is that correct?
Yeah, they argued that the summary should have indicated that the DUI law was in some sense modified by the new standard that the initiative imposes. And it's true that the initiative does change the DUI law as it applies to adults over the age of 21, but they said exactly what that change is. And the summary, Smart and Safe, is pretty clear that it prohibits drivers from driving while they're impaired. And so it's a true statement. What's the statement in the summary is actually correct. It's just that they're trying to say that, well, but you can't just convict someone based solely on the presence of metabolites. In other words, this new smart and safe law will make it impossible to convict someone just because they have marijuana in their system. You have to actually prove that the person was impaired. The state will have to prove that. That's the new standard, and that's the standard that's in this summary. So there's nothing incorrect about it.
Yeah, that was a weird one to me because it is clearly in the summary. I mean, the summary says it, so I couldn't even follow their argument as to why that was misleading or insufficient. The summary calls it out and specifically says it.
Gary, can you help us with the logic there?
You're assuming there is some. I don't understand their argument either. I didn't think it was compelling.
Robert? Sam?
So I think when all the lawyers are stumped, you can go to the political guy. And I think that for, I will definitely not offer any legal interpretation of that, but I think—
Don't worry, we didn't either.
Yeah. When you look at something like this through a political lens, right, I think, the very fact that there could potentially be a news story about questions around DUI or questions around tax, right? I think that is the aim that this effort could potentially, go for, right? To just the idea that the question is out there could translate into unknowing. So we know here that it's factually absurd, but that doesn't mean that the media won't talk about it, and the very fact that it's part of the zeitgeist is problematic.
No, actually, that's a great point, Sam. I've been gifted because I can also think like a monkey, and I can see where there can be that confusion, like a well-educated human being and a monkey both, I'm really in touch with my animal natural side. So, but I can see.
Refocus.
Well, I'm more focused on that image behind you, Gary, than you. So that's.
Yeah. Can I say one more thing on this DUI nonsense?
You can say anything you want, as long as you're not promoting your book.
No. I would never do that. I would never promote my book. The whole DUI thing, we constantly hear this refrain over the last several years, and I'm sure for years to come, about, cannabis is going to cause all kinds of impaired driving, and people are going to. Listen, I have yet to meet anybody in the cannabis world who supports impaired driving. So audience at home and people who might look at this video in the future, not a one of us, nobody on this panel, nobody in our audience supports impaired driving, for God's sake.
And let me just say this, let me add this. Here's the thing with marijuana and impairment. To the extent that marijuana might impair at all, we know conclusively from studies done, numerous studies over the last few decades, that if there's any impairment, it's going to dissipate after approximately 2 hours of smoking, vaping the marijuana. So there's a 2-hour window of potential impairment, although that most people who smoke on a regular basis actually drive better while they're under the influence of marijuana. In other words, it's more of a performance enhancing substance than an impairing substance. But for those who might be impaired, that's a 2-hour window. Yet those people will have active THC metabolites in their system for several days after consuming. So the idea is, how are we legalizing marijuana if we say you can't drive, because effectively you're automatically DUI every time you get behind the wheel if you've partaken in any time in the last several days? It doesn't make any sense. So this was meant to, the change in this law was meant to recognize that and say, you can't drive while impaired. If the state can prove that you were driving while you're impaired, then you're guilty of DUI. But we're not going to make you automatically guilty just because you happen to have active THC metabolites because you consumed 4 or 5 days earlier. So that makes perfect sense. And I don't think any better way that it could have been stated than it is in Smart and Safe. So, there is no such thing as legalization without eliminating that automatic metabolite immunity. And so that's what this initiative did.
Yep. And Tom, the judge really honed in on that exactly. He said, to the plaintiffs, he said, well, how in the heck would the reasonable voter vote to legalize marijuana and not assume that it was going to, that we weren't going to change the the zero tolerance limit for marijuana in the bloodstream or metabolites. So he really honed in on that, and I think had a good understanding of that.
I think, and Sam, I want to thank you for that. It was a very astute observation about the perception versus reality, because I think we will see more news stories about that in regards to, you know, taxes, burden of proof, DUI, that kind of stuff. So as I'm trying to be accurate and factual here, you bring me back into the reality that there is no reality. Damn you. Anyways, whatever. So let's move on. Let me ask another question. You know, they dropped it's federally illegal. So they argued to the court because it's a large and complex omnibus bill, and contrary to federal law, it should be invalidated. That Shadag did that at the beginning. And you guys catch that? What
Mm-hmm.
for shits and giggles, can we talk about that for a second, Robert?
Sure.
Ryan's rolling his eyes.
This is an argument that raises its ugly head every time the same group of opponents of the liberalization of marijuana laws show up in court. And what this has to do with is the fact that, you know, under our legal system, under our Constitution, federal law will preempt state law under, you know, certain circumstances, most circumstances. I have no intention of getting into the weeds about that doctrine during this call, but essentially the upshot is that the opponents of this law, and by the way, this foreshadows some of the challenges we can expect after this initiative gets passed, will be arguing again that none of these state laws are constitutional, and they should all be stricken because they're preempted by federal laws that make the use of marijuana and the manufacture and all the rest criminal.
Excellent. Brian, did you want to chime in there? I know you were rolling your eyes even at the thought of this because of it seems legally absurd, but the people need to understand that the argument's invalid. So if you could talk about it a second.
Sure. Yeah. I mean, it's like Robert said, it's the same argument that gets trotted out every time: is how can a state legalize something that is illegal federally? But every single court that has looked at it has ruled that the Controlled Substances Act does not preempt the field, and that the state is free to change their own marijuana laws how they see fit. And so that argument rings hollow. I mean, it's every single court that's looked at it has decided it the same way. And the CSA in its text specifically says it doesn't preempt the field.
Right. That's right.
And this is something I noticed in the initiative, the severability clause. Is that one of the reasons why they attacked it based on the summary aspect? Because the severability clause at the end allows, you know, pieces to be taken out if they're invalid, correct? Or is that, how does that work?
Yeah, that wouldn't come into play with regard to the argument on the 100-word summary. That would come into play later on if a specific provision is found to be unconstitutional. It wouldn't invalidate the whole law.
Okay, so that comes in the if there's a challenge after the voters pass it.
Correct.
Right.
Okay, that's what I was wondering about, how that worked.
Although if is probably not the right word.
Yeah, no kidding.
Well, what do you predict in the capacity of that? How will that work process-wise? I mean, the voters are anticipating getting to vote, passing this in November, and we'll get into the time frame as to when it's enacted. But what were you suggesting there?
Well, I give it about 6 months before another Rodney Jones is targeted in Yavapai County, but this time for possession of recreational marijuana. And we'll once again be fighting the good fight about why this act is, why what he was doing was lawful and why this act isn't unconstitutional. It's just to be, remember everything that happened with Emma for the past 10 years? Just remember, you know, press the repeat button.
Well, and just process-wise, can somebody file a legal challenge to this after the initiative passes in November? Is there a constitutional challenge that we filed, Ryan?
Yeah, this was what happened with the Medical Marijuana Act when Governor Brewer filed their lawsuit in federal court, trying to say that, again, making this argument we were just discussing a few minutes ago regarding the federal law conflict and the supremacy clause. Ultimately, that action was dismissed out of federal district court. But it was a constitutional argument saying that because of the supremacy clause under the United States Constitution, that any law that it somehow contradicts or is inconsistent with that federal law has to be struck down. And that, again, as everyone here said, that's been roundly rejected by our own Supreme Court, as well as in that case, federal district court.
Ryan, did you want to jump in there?
I think Robert and Tom covered it pretty good, but I'm certain that we'll see any number of different challenges to the law in general and to specific provisions of the law. Prohibition dies hard, and what they say is that when they say a baby cries the loudest right before it gives up and falls asleep. So I think that's kind of where we're at in this phase of prohibition is, they're screaming as loudly as they possibly can because they know their day is over.
I like that.
Love that you just used that metaphor, Ryan.
No, that was good.
Here's why. Alcohol prohibition lasted 13 years in the United States, and one of the main reasons that it was repealed was the need for more tax revenues. And the big pitch was given, hey, we can tax the crap out of alcohol. And Roosevelt said, sign me up. So that is how prohibition got repealed. It was principally to raise tax revenues. And right now, our economy just took a 30% hit. So, oh my God, what a great opportunity for cannabis to be this generation's alcohol.
A couple of housekeeping notes. On your Zoom, if you want to change your name to your email addresses, people can write down how to get a hold of you. If you just during this time, change that. Also, remember, we're not regulated by the FCC here, so you can curse. I said shit earlier. Feel free to. I mean, we've got to maintain a certain dignity and professionalism, but just keep that in mind. I was just thinking about that. So
you don't have to wear pants.
Yeah.
Oh, well, that's something entirely different, Kerry.
Yeah. I want to ask where he's going with this, Tom, but that will probably be another Zoom call too.
We don't want to know.
No,
actually, before we leave that conversation, I just want to highlight, because we've kind of nibbled at the edges of it, but just to drive the point home that elections have consequences and there are prohibitionists in all parties. So it doesn't matter how you're personally registered to vote. When you get your ballot in November, remember to ask whether or not the candidates that you're voting for support federal legalization, because that would be one real easy way to avoid the supremacy clause being an issue, is to make sure that there's federal legality, and supporting the end of prohibition is a great way to ensure that happening.
So, I invited all y'all to talk about what you guys know best and what you probably dream about at night. We have like 30, 40 questions from the audience, and I want to get to those because people submit them on Eventbrite. They take the time to write them out. But real quickly, last thoughts on what you saw today, what you've read in the initiative, what you think is going to happen. Read the tea leaves, because a lot of people are out there asking, these guys are the experts, while they can't get into the judge's mind, employment, employers, investment, there's a lot of things at stake here, in patients' rights and consumers' rights, et cetera, et cetera. What do you think? What else do you see? Just feel free to.
Well, one comment right out of the gate is nobody panic. Judge Smith will do whatever Judge Smith does, and I'm sure he will do a very, very competent job. But understand, this doesn't end in the trial court. This is going to end at the Arizona Supreme Court, and theirs is the only opinion that matters.
Brian? Oh, who wants to go next?
Well, I think this will be an interesting test of, the current composition of the Arizona Supreme Court, which is, has been changing. But in the end, given the tests that they've laid out in prior case law for whether or not this 100-word summary meets the, requirements of the statute, I think they would be hard-pressed to find that it fails to meet that standard. And so, you know, at the risk of you know, lawyers probably shouldn't make predictions like this, but I think that at the end of the day, the 100-word summary passes muster.
Yeah, I sorry, I was having some technical difficulties there, but I agree with Rob. You know, it's a really high burden to show that the summary was misleading or fraudulent in some way. And in general, the judge, you know, the appellate court and the Supreme Court of Arizona are reluctant to prevent the voters from having their say in something. You know, the right to direct democracy is something that's enshrined in Arizona's Constitution. And so generally speaking, courts have upheld that right and given relatively wide latitude to make sure that the voters get to have their say. So even if the Superior Court judge comes out with a wonky ruling and says that the initiative ought to be tossed, I have faith in the appellate court and the Arizona Supreme Court to do the right thing in the long run.
Tom? Sam?
I was going to say, once it does make its way to the Arizona Supreme Court, it'll be interesting to see if Bill Montgomery, you know, recuses himself from the process, because now, you know, most people probably know that he used to be the county attorney here in Maricopa County and a very outspoken anti-marijuana crusader, anti-marijuana policy reform crusader, now appointed by Doug Ducey, Governor Ducey, to be on the Supreme Court. You know, be interesting. I don't know if there's any legal reason for him to recuse himself, but if he does rule, it'll be very interesting to see how he rules. Will he just go along with his political, you know, what his political career has been, or will he actually make an independent, more judicially neutral decision? So that's something I'm just interested in. It's kind of an aside, but it'll be interesting how Bill Montgomery weighs in on this.
And Robert, you have tremendous insight on the Supreme Court. What do you see from your knowledge of their personalities when they get a hold of this?
You know, it's interesting when judges get to the high court, whether you're talking about in a state or the U.S. Supreme Court, they often surprise us in terms of the decisions because they're now facing a different set of variables. Whereas Justice Montgomery, for example, came from a law enforcement background, prosecutorial background, where he was zealously opposed to the, you know, AMA, for example. I think that, you know, we may be pleasantly surprised by his and other justices' ability to kind of separate themselves from the politics of it and look at it from, you know, the perspective of the importance of the franchise that's been given to the people of the state in our Constitution. Because as much as you may not favor the policy of this initiative, there are plenty of initiatives that you as a justice will be supportive of personally. You don't want to see this process sustain injury or harm as a result of a precedent that you're establishing that could have far-reaching consequences in the future.
Sam?
I'll zoom out a little bit. I mean, obviously, we're all on this call because we care about the cannabis industry and even more specifically the Smart and Safe Act. But the challenges that we're seeing here with this campaign really are in line in general attacks on the overall initiative process here in Arizona. Ryan mentioned earlier, this is part of our Constitution. And in fact, we, as Arizona, used this mechanism to be ahead of the curve on women's suffrage. We passed the right to vote for women here in Arizona about 10 years before the 19th Amendment. So this has been part of our process here for decades, if not centuries. We're only in, you know, the second decade of our second century, but whatever. I'll be flowery in my language. So and in recent years, I think as folks have seen kind of the power of using this vehicle to do things that the legislature will not. The legislature and folks that have their handles on the levers of power are very interested in making it much more difficult to go to the ballot. So there have been increasing rules as it relates to compliance. That's why the basic effort of gathering signatures is so difficult. We have, as mentioned here, right, 17-page initiative for a 17-page filing, over 100 words, right? So all of these legal motivations to block the process are at times less about the actual idea in the initiative and more about the initiative process itself. So just wanted to mention that for folks on the call wall. We definitely, as supporters and patients and general cannabis enthusiasts, I think feel more attacked in this than we might otherwise. It hopefully will give you some solace, at least, that every initiative that is filed for signatures has a legal challenge, if not exactly like ours, somewhat similar on their path towards the ballot this November. So just wanted to kind of zoom out and add that context.
We have some specific questions that are related to the topic of the lawsuit itself. Does anybody else have anything that stood out to them in regards to reading the lawsuit against the initiative or the arguments today that they want to bring up?
Only, Dimitri, that I think they should abolish this statute that requires a 100-word summary. Because what you're actually doing is, I mean, let's face it, what if you were dealing with an initiative that was 100 pages long or 200 pages long with, 60 different principal provisions, or 100 for that matter? You would not be able to describe it within 100 words.
I'm going to try to describe myself in 100 words.
I think that kind of makes the point, though, in a way, doesn't it, Robert, that this is meant to be comprehensive. This is meant to just give a little bit of a gist or an introduction to what the subject matter is, because you couldn't possibly cover a 100-page initiative in 100 words. So that just underscores really this isn't about covering all bases. It's just about giving the voter an intro so that they know the subject matter really of what they're dealing with.
Yeah, even the statute itself says that much, Tom. You're absolutely right. It's one little sentence. Let me just read this to you, because the statute, besides the 100-word summary, also requires a notice underneath it that, per the statute, says this is only a description of the proposed measure prepared by the sponsor. It may not include every provision contained in the measure.
Right.
You're told up front, read the whole thing if you really want to know what it says. It's up to you as a voter if you want to read it.
I'm thinking about filing a lawsuit against the girl I met on Bumble. I'm just kidding.
But seriously, I think this provision may actually be unconstitutional under Arizona's constitution, because I think that would be an interesting lawsuit right there.
No, that's fantastic.
I mean, because if you have a number of principal provisions, many more than ours, for example, in this initiative, you would not be able to fit it into 100 words.
Yeah, I think that's a good point too, because I think, as Gary was mentioning earlier today, about many states, their initiative process is found by legislative action. It was created by statute. In Arizona, ours is grounded in our Constitution. So any attempt by the legislature to try and change it in any kind of material way, arguably is, it definitely does invoke constitutional concerns.
Those of you who don't use Bumble, you're required to do a little description of who you are. So it never quite summarizes who they are.
Right, just cut. That's enough, Dimitri.
Sorry. I'm transparent. I'm transparent, Tom. Okay, back to the thing. We have a question. Burden of proof. What's the burden of proof here? What's the standard of the,
standard is on
reasonable doubt?
Standard is on the plaintiff, and I think that I think the judge underscored that in his comments during oral argument was it's the plaintiff's job to prove, I think, by a preponderance of the evidence that the language is confusing or fraudulent.
And God bless the judge for pointing out that they presented no evidence.
It's interesting. I don't see in the Supreme Court decisions that I've been reading on initiative procedure, I have not seen them reference the standard of proof. Obviously, they talk about whose burden it is, but in terms of whether it's a preponderance of the evidence or clear and convincing evidence or beyond a reasonable doubt, you really don't see a whole lot of reference to that.
Is it in statute somewhere? I mean, somebody was asking what level do they have to rise to?
Yeah, I saw that. I have not seen it.
I think generally, if it's not clear and convincing or
It's
beyond a reasonable doubt,
preponderance.
it's probably going to default to preponderance. Yeah.
Yeah.
Yeah, I think the judge said that in the hearing, is that it's
Yeah.
a civil burden.
Yeah.
More likely than not.
Excellent. Another big question is, I'm not sure, there's anything, what can I do to help? That's what people want to know. And I know Sam's going to turn this into a fundraising call, but we'll get to him in a second. But is there anything anyone can do to help? Any crazy abstract ideas?
In the court's hands now.
Yeah, I mean, you could certainly try to write a letter to the editor, and maybe that the judge sees it before he makes his opinion. But,
What you do is don't vote for people who are federal, state prosecutors who are backing these types of anti-liberalization initiatives. I mean, that's the problem, is that a lot of these law enforcement officials are elected, and folks don't know who they're voting for. So they need to educate themselves, or they just need to go and vote to counterbalance the people who are voting for some of these people.
And we do have pro-change candidates
Right.
to be running. So
Right.
you have the opportunity to vote for different people.
You do.
Tom?
Yeah, I think if you want to know who to vote for, if you go to normal.org, they have in Arizona a list of pretty much every statewide office, and even some local offices. They break it down by who's the most cannabis friendly. So if you go to normal.org, you'll find there and I think also on Arizona Normal's chapter site, you'll find a list of a voting guide on how to vote. So if you're interested in knowing who those persons are, then check that resource out.
Sam, here comes that softball to you.
Well, I just think that right now it's, to make sure that you're looped in with what MEDA's got going on, with what the ADA's got going on, and just ensure that you're up to speed on this. I think a big part of how folks can push back on prohibitionist lingo and kind of the falsehoods that they put forward is to normalize the use and make sure that folks understand that they know a cannabis user, that they know, a qualified patient, and then the efficacy of some of these arguments out in kind of the non-legal land, completely lose weight, right? Like there was this American Heart Association survey or report that came out earlier today, and a bunch of prohibitionists glommed onto it, and they totally glossed over the fact that the number one recommendation that the association made was to deschedule cannabis so we could research it more. And the second thing that they said was explore all of the different ways to ingest cannabis, not just smoking, because we know that might be, something to watch out for. But, I think I wanted to take that opportunity to underscore the importance of normalizing it. And I know that MEDA does a lot in the way of that. At the ADA, we're hyper-focused on professionalizing the industry. I mean, we have very skilled attorneys, as you see on this call, that are part of the cannabis community, as well as very skilled and competent business folks that have been operating multi-million-dollar operations that contribute significantly to our sales tax revenue. And at the same time, you have the supposed business leaders at the Chamber of Commerce and Industry saying that we aren't an industry worth their time and energy. And my favorite thing that I would like to do on the evening of November 3rd is receive a call from Glenn Hammer apologizing. I'll say that in public.
I don't think he'll apologize. You forgot to mention how people can donate to the campaign.
Oh, I said it right there, and I was told not to self-promote. And
No,
that's
who said that?
I do now. So it's just right here. Donate. You go to smartandsafeaz.com, and there's a link to donate right there. Obviously, we have to deal with this legal challenge, and as more opposition comes out of the woodwork, we're going to have to make sure that we get out to each and every voter and make sure that we cross the finish line. So thanks all for your support and your attendance tonight.
There's nothing wrong with a little self-promotion, Sam.
Dimitri, I'd also add, the donations and supporting the campaign is important, but make sure that you're talking to your friends and family and talking publicly about this on your social channels. It's real important that we turn out the vote. We get everybody united behind this effort. And you'd be surprised as how some of your family members might come down on this. So have the discussion with them. Have the discussion with your family and friends, and make your position known publicly so that other people can support it as well.
Okay, so let's, we've gone through a lot, we got to the substance of this and kind of showed how it's kind of a meaningless thing. But so, somebody in New York is talking to somebody in New York about, have you heard they might throw it off the ballot? Arizona might not be voting. What's the message out there? Like, because let's start to sum up. What's the message out there for members of the cannabis community, Arizona, nationwide? What's going to happen in Arizona? Read the tea leaves. Give us your, what's it called when you look into the future, crystal ball. What do you see happening?
I think, listen, the point is that they do this every time. They file these lawsuits every time and they never win. They've never once been able to shut down, since the Voter Protection Act anyhow, never once been able to shut down a marijuana related initiative, whether they filed the lawsuit before the vote or after the vote. So I don't expect, if anything, their chances of prevailing now are even less than they were before.
Ryan?
Yeah, I think that's the message. And I think the deadline for printing ballots is August 21st. So we will have a definitive answer one way or another by then. But Tom is right. These challenges are frequent, but not frequently successful. And I think this one in particular had some pretty weak arguments. My crystal ball says the judge rules in our favor. The appellate court upholds it, and the Supreme Court declines review.
Yeah, to catch up with that for a second. Gary?
I'm going to adopt the Hitchhiker's Guide to the Galaxy and quote it and say, don't panic.
Don't panic. Robert?
Answer to life, the universe.
I think that we get past the initiative challenge, and then I think everybody needs to look soberly at the fact that while we think the other side their arguments have been frivolous, they've also had they have had a significant amount of time to continue honing their arguments and sharpening them, and I think the industry has to be prepared to defend itself with through the legal system, in addition to getting some of these folks out of office. I think we're going to have quite a bit of litigation, and people are going to have to open their pockets to pay lawyers to do that stuff, especially Tom.
Oh, hey, listen, my thing is criminal. There definitely will be, I'm sure, a lot of issues to come up, just like in medical. But yeah, these are both. But we're going to see challenges that directed like this one, more or less, you could say, directed at the industry. It's the industry who's fighting this battle this time. You're going to see those challenges come on kind of an overall basis, attacking the initiative itself. You're going to look to the industry primarily to defend it, the initiative, but then you're going to see individuals, being attacked by persons who are misinterpreting provisions in a way that the initiative didn't mean them to be interpreted, and so a lot of times those are the kind of people that I end up having to help when they're in busted or in jail or whatever. Then so it's a team effort.
Yeah, it is.
Excellent. So we're gonna, we've covered a lot of good information, and most importantly, people know who you guys are out there in the community. This is like networking, and you're gonna get random people contacting you saying, "I saw you on a Meet a Zoom call," blah blah blah. So you'll look forward to that. We got to do our screenshot, so you got to smile for the camera. Everybody, good. Did you get that, Destiny? Okay, she got it. That's the one we use to attach to the video on YouTube and all that kind of stuff. You want another go at it, or are we all good with that? Okay, so let's do some closings. And feel free, again, remind people who you are, how to get a hold of you. We got the emails up there, what you're about, so they can know who are the people in their neighborhood. So go ahead, Tom Dean.
Well, let me just say this. I'm happy that this initiative, Smart and Safe, was written the way it was. There have been a lot of improvements, let's say since 2016, in my view, that favor consumer rights and protections that I think make this initiative, far and away a superior initiative and one well worth voting for. So I hope that, consumers and vote and just non-consumers alike will look at this and understand, especially in this day and age when we're concerned about things like sentencing reform and criminal justice, that this goes a long way towards moving in that direction, while at the same time respecting the institutions that we have here in Arizona, including even law enforcement. So this is a very well balanced overall initiative that I think ought to pass, and if it does, is going to do a lot to both increase tax revenue in the state of Arizona and go a long way towards protecting individual rights, especially those persons who are in our criminal justice system.
Thank you, Tom Dean, and your email and phone number is behind you, so thank you.
Yep.
Ryan Hurley.
Yeah, I echo Tom. It's been a long 4 years since that horrible night in November of 2016, and this is our opportunity to make it right. One of the reasons I think we came up a little short last time is we were not as united as we are today, and I'm really happy about that. The initiative that we have today is light years far and away better than the one we had in 2016, and I can tell you this is our best shot. So everybody needs to support it vocally, financially, if you can, volunteer when it's time, and get out there and let's make sure that we're no longer the only state in the union where possession of any amount of cannabis is a felony. So let's end that. Let's end that prohibition and let's move forward.
We got a great screenshot, guys. Okay. And Ryan, don't forget Copper State, General Counsel, brand.
Soulflower, thank you. I lack
Soulflower.
of promotion. My email is in the chat if anybody needs to get a hold of me.
All right. Just throwing that out there. Who's next? Gary? Close up.
You go next. Well, same as we started, as we end. I'm still Gary Smith. I'm still a lawyer. Still doing cannabis law for the last decade and probably will for the next decade. The big takeaway for me is I'm expanding beyond cannabis now into all plant medicines. And of course, cannabis is a plant medicine.
Mm-hmm.
And of course I support it. I support total decriminalization of all plant medicines. And I think that as people come to understand that there is a huge history behind these things, none of this is new. Marijuana is not new. Relax. It's just the last 50 years that some very conservative people got really weird about it and forced that on us. But we outnumber those folks now, and they're a dying breed. And just be patient, relax, have faith, and just trust the people are going to be responsible, because as we've seen over 10 years of AMA, shocking, people have been responsible.
Yeah, the world hasn't. Yeah.
Crime has not spiked up in Arizona as everybody said it would. In point of fact, pull the statistics from the Department of Public Safety here, and you will see since AMA was enacted, crime has gone down in every major category in Arizona. Every category. So have faith and buy a book on Amazon.
And no, that's okay. Yeah, you got to get me, Gary. We should have you on here just to talk about your book.
Say the word, man.
And
Twist his arm.
Yeah.
The thing about his book is it's smokable. Actually, it has a mild plant-based medicine that's in it. Am I supposed to give that away, Gary?
I'll share one more since you're giving my secrets away. Page 44, scratch and sniff.
All right. Well, Robert, so tell us a little bit more about Zuber, closing thoughts.
Well, I'll tell you this. I do think Gary made a point earlier about tax money. I do think that money talks. Right now, my law partner here in Phoenix, Janet Jackham, and myself at Zuber Lawler are receiving phone calls every day about new transactions that are going on in the marketplace. And I think that at the end of the day, the types of revenues that this industry brings to the state and will continue bringing to the state will continue to influence people increasingly to be more supportive of this industry. And so, I think that once we get past this initiative challenge, there are going to be those types of political pressures are going to be more favorable to us.
Robert, I wish I met you 4 or 5 years ago.
Well, I thought you did.
When I needed a transaction attorney.
Well, that's Janet mostly, but you know, we're here for everybody. We have 48 lawyers throughout the country who make this a very central part of their law practice.
Sorry, that was a slight reference. I think Ryan got that as he rolled his eyes.
Did I miss something?
It's all right. Don't worry about it.
Oh, I think I know what you're talking about.
Yeah, you guys all know what I'm talking about. But
Yes, we do.
So, Sam, you're up. Close us out. I love, by the way, folks out there, Mita and the ADA are working really, really well together, and we're trying to round up everything and go forward, charge forward. It's been really, really good. And Sam, you have been an unbelievable asset, and you are so smart and so talented, and so just love working with you. So, but go ahead and maybe close up.
But I'll give you your $20 after. It's fine.
Yeah,
Thank you. No, it's always a joy to be on here with your great, fantastic audience. You always get great numbers, and very, very grateful to be here. I think I'll be very brief and just say that once we get through these hurdles, we will be laser focused on November 3rd. So if you haven't recently, please update your voter registration right here at servicearizona.com so you can be all set to go to vote either by mail or at the polls on November 3rd. With that, I want to say thank you so long, and thanks for all the fish.
Yeah, and folks, we are going to have some very exciting webinars coming up. In 2 weeks is our next one, and we're going to be featuring hopefully Copper State, actually, like Harvest, Copper State, Growers House, Hyper. These are Arizona-based companies that are bringing in national dollars through their national expansion, which means employers and employees back home. The money's coming into Arizona. So Mita is going to be working hard in the next few years to try to help Arizona understand how the growth of cannabis as a whole and cannabis companies that are working nationally, internationally, headquartered in Arizona is good for the economy as a whole, which is an exciting thing. So in 2 weeks, we're going to be featuring homegrown companies that are doing nationally. We also have some social equity panel discussions coming up, as well as how to network in cannabis, but it's all on www.mita-az.org and sign up for our email list. You get all the information. So thank you. Don't leave, you guys. As we close out, we always play this song now, and it's going to get redone, and you got to look left, look right. And thank you for joining us.
Thank you.
Wait, don't leave.
We're all in different boxes though.
Huh?
Good. Thank you.
We're not lined up the same.
Wait, just let me, it's not working. Okay, it's not working, but I'm going to get this redone. It's the Brady Bunch theme song, and you got to get used to saying, but anyways, we'll get that going later. Thanks guys for coming. Appreciate the audience. Thank you.